So to set the stage for these intellectual arguments about workplace democracy and political democracy and all that, we have to start with the sort of traditional way in which these normative questions are framed. As usual in these fundamental questions, it's not so much the answers that differ, it's how you frame the question. And once you frame the question, the answers are pretty clear. The sort of fundamental framing is it's consent versus coercion. And the basic necessary condition and some sense sufficient condition for an institution to be acceptable is that it's based on consent. And that any institution based on coercion is unacceptable. And the problem comes out right away in that if you go back and rather than read sort of normal liberal intellectual history, go back and look at the actual intellectual record of the sophisticated offenses of even slavery, as well as autocratic, non-democratic government, they were all based on arguments or basically contractual arguments. I have to start out by recovering that history, that intellectual history of the sophisticated, if you wish, even liberal contractual defenses of slavery and autocracy. And those defenses go right up into modern times. The basic, what's called the fundamental theorem in conventional economics is that, well, that means a system where all markets, all transactions are allowed if you have a willing buyer and a willing seller. So that includes selling all your labor at once. So because if you try to truncate the future markets in labor, then you might have a willing buyer and a willing seller for some labor way in the future, and so you couldn't have an efficient competitive equilibrium if you didn't allow those transactions. So here is the case where an economist, by no means a radical economist, in fact, he's a famous econometrician at Johns Hopkins University in Baltimore, in congressional testimony saying that if we really want to look at conditions for the free market to be allocated to be efficient, we have to allow people to sell on market themselves. So this is not just not a philosopher at Harvard, this is also sort of standard economic theory that if you think it through, and he did, also requires that we allow unlimited future contracts in labor, in other words, selling all your labor at once, and that's essentially the voluntary slavery contract. Now, how about John Locke? Well, John Locke is, of course, the key figure in the history of classical liberalism, and it turns out that if you read Locke carefully, you see that, in fact, he had no trouble with a voluntary slavery contract if it was actually a contract. And then Locke wrote the Constitution for the Carolinas, which had slavery, and so the question was, how did he write slavery into that Constitution? And he interpreting the slaves that were brought over from Africa as being prisoners of war in some war inside Africa, where they had chosen to become slaves rather than be killed by their captors. And so the third form of contract, we had the individual self-sale contract, we had the collective pactum subjectionis, and the third form was the old form of the marriage contract, which was also a personal alienation contract, where the woman gave up her independent legal personality in favor of the husband. So the idea was that the younger woman was under the cover of the coverture of the father, and then the marriage was changing her from the cover of the father to the cover of the husband. So, what is the counter-argument now? So see, if you frame it as just coercion versus consent, then the argument is just, well, we should have government based on consent. But the real argument has always been against these more sophisticated notions of consent, pactum subjectionis. And there was a whole history of people developing arguments against that. There are some forms of consent, as you can imagine, the voluntary slavery contract, which have something inherently wrong. And so at the same time we have to resurrect the framing, we have to resurrect also the counter-arguments, the real theory of inalienable rights. And that's where the notion of inalienable rights comes from. It's this whole idea that there's something about these rights that the contract only pretends to alienate, and the contract is in some sense inherently bogus. The voluntary inalienable institutions where you don't allow those sort of contracts, where all political constitutions are democratic, and so the rulers are seeing them as the delegates and representatives of the people that are governed, and then in the workplace, that is the economic democracy. If you go back in history, the germ of the idea is back in the Stoics, who said that the slave is a slave only in his body, not in his soul. But so the idea, this internal freedom of the soul, as opposed to the bondage of the body, sort of been underground for centuries, and really seems to have erupted again in full force in the Reformation. And it's basically came out as Luther's notion of liberty of conscience. And so the idea here was that Luther said we cannot alienate the decision-making power that we have over religious beliefs. We cannot say, give that up to the church, we cannot give that up to the Pope, and we have to read the Bible ourselves and make our own decisions about this. And so the decision-making power that each person has as to what they will believe, that in other words, their conscience, is inalienable. So that transition seems to be made by two people. Spinoza wrote first. Even with consent, there's something inherently wrong with this type of contract. However, the place that really entered into the Anglo-Saxon tradition was Francis Hutcheson, who was a professor here in Glasgow. He had the chair of moral philosophy. He was Adam Smith's teacher. Adam Smith took the chair after him, so it was often considered to be the father of the Scottish Enlightenment. It's Hutcheson that was the key one, because the colonists in America read and appreciated more Scottish thought than English thought. So it was through Hutcheson that this got into Jefferson and into the Declaration of Independence. So the question is, who was this person that plagiarized by Descharcot in the encyclopedia with no mention of who he was? And it turns out he was a Scotsman by the name of George Wallace, or Wallace, and who, fortunately, is very obscure. And we know so little about him, we don't even know what his years were. We don't know when he was born, when he died. And the other way Wallace's work got promulgated was by the Quaker abolitionist pamphleteer Anthony Benson. So now let's go to the political version. That was the individual anti-slavery contract. So let's go back now to the political version. Contracts of alienation versus contracts of delegation. That was the key distinction. This act by which the people gave up their power to the prince, and to interpret it as a contract of delegation, not a contract of alienation. And that was really the source of democratic theory, was this reinterpretation. So it wasn't, consent versus coercion. It was always, the sophisticated debate was about consent. Or was it consent to alienation, or was it consent to delegation? Then the two people in the early, or late Middle Ages, early Renaissance, were Marcinus and Marcellus, both of whom were Italian scholars, and they're the ones that really developed that whole distinction, and then of course argued that the implicit social contract with the king should be seen as a delegation, not as an alienation. So that was the start of the whole democratic theory in modern times. And another version of this, and here we get back to the Scottish influence, was John Mayer, who is often called the last scholastic. And he taught in Paris for a long time, but then at the end of his career came back and taught in Glasgow and maybe St. Andrews. But the idea here was what was the election of the Pope. We just had an election of the Pope little bit ago. And what was it? Was that a delegation? Was that an alienation? And so is the Pope a delegate of all the people in the church? Or was that an alienation of the right to govern the church to the Pope, who then governs with some sort of divine authority? And they said, no, he's a delegate. I mean, one of my year students, Buchanan, was even more important in the subsequent development of Scottish thought, and expressed the same idea, that the contract between the people and the ruler is a contract of delegation, not a contract of alienation, and the ruler doesn't own the people's power. So I want to finish up here by actually saying what is the modern treatment of this theory. And the idea is always to look at the factuality behind these contracts, and that you have two things to consider. That if you have just take a simple, silly example. If I make a contract to be a frog or a donkey or something, then obviously I can't fulfill that. But yet we can have a legal system that said, well, if you do this and this, like obey your owner, we'll count that as being fulfilled. And then we'll enforce your legal rights as if I was a beast of burden. That's sort of the idea, that there are certain contracts which you actually can't fulfill, won't fulfill in the execution of the contract, but the law says we will interpret your obedience to your lord or master, your husband, or to your master as fulfilling it, and then we will enforce the legal consequences. So in some sense, it's a massive flaw that because you can't actually alienate your responsibility. So your decision-making power in the original, you go back to Luther's main point was you can decide to believe whatever the Pope says, but that's still your decision. You still have to take responsibility for that decision. If that's the way you want to make your religious judgments, fine. That's your decision. You cannot alienate that power, and you still have responsibility for your religious beliefs, even if that's the way you make that decision. And this idea carries right through if you look at from the sort of property point of view, what happens in a rental contract? If I rent you a car, or I rent you a shovel or something, well, I can stop my use of that car and turn it over to you to use. I can stop my use of the shovel and turn it over for you to use. But when I rent myself to you, how do I stop my use of me for you to employ me? There's no such thing, that I still am, still make my own decisions. I make decisions maybe to do whatever you tell me. Fine, but I still am inactionally responsible for that. So the way to sort of see this is to take the example of a hired criminal. Both at the status of a slave, which could be a contractual slave, or the status of an employee and a rented person. And you say, well, what happens if they commit a crime at the behest of their employer, of their master? And in both cases, you have the law treated entirely differently. The law then recognizes when a person commits a crime that the slave is not a thing at all. The slave is a responsible person. The responsibility was never alienated. And the slaves were held responsible at the law for their crimes they committed. And the same with the employer-employee. This is from a British law book. But the point is that when you cooperate together with your employer and you engage in a criminal venture, there is no employer-employee. There is two human beings who jointly engage in a criminal activity, and you're jointly, in fact, responsible for that, and the law recognizes that. So the point here is, how does that change when the activity is not criminal? When you go into a normal firm and you do what the law says, and you're still a responsible person, you're still co-responsible together with the employer for what is work of the firm. The firm is inexorably a de facto community of people that jointly carry out certain activities, but because of this contract, which says, as long as you don't commit a crime, we're going to consider this contract as fulfilled if you obey the master. And then you have no right. You are simply a cost item. You get your wages, the rental payment for your labor, and the employer appropriates whatever's produced and is liable for whatever cost you incurred. So you're just a factor of production, the owner of a factor of production, which you're in now. So the sort of higher criminal example is the sort of eye opener, the intuition, what we call an intuition pump, that you go back to and say, okay, I understand here that responsibility cannot be alienated. And it doesn't change. When people go into a normal firm, they don't suddenly become robots or instruments. But the law changes. The law says now we enforce the employment contract. The employment contract is now valid. You can't have a contract valid in a crime. No crime is committed, it's valid, and therefore we enforce the consequences, which is you get your wage and the employer gets everything else. So the result here is that there's something inherently wrong with a contract preventing human being. That human beings cannot give up the use of themselves and turn it over to somebody else, just the way you can do that for a car or a shovel or something else. And we're not saying here, by the way, that people should not eliminate the responsibility. We're saying they cannot. And that's not something you do. What you at best do is to agree to cooperate with your boss, and you are actually co-responsible for whatever the results are. So it's a question of fact. It's the legal system that says, well, if you don't commit a crime, we'll consider this a valid contract and so forth. So basically, the upshot of this argument is that this whole contract for renting human beings is bogus. It's the short-term version of the sell-sale contract. The sell-sale contract is abolished. That was abolished along with the involuntary slavery, the Emancipation Proclamation in America, and similar legislation elsewhere. If you took some city in America and you got the people to vote to give up the right to govern themselves to some corporation, that would be unconstitutional. That would be thrown out in no time, as it was thrown out in Honduras. You tried to do it down there. And the coverture marriage contract was also abolished. So the real contract that's left from this legacy is the employment contract, the contract by which capital hires labor. And so if that contract was invalid, as I've argued, then basically that means that you would only have, in the organization of production, only have labor hiring capital, not capital hiring labor. So let me essentially end on this quote here from Lord Eustace Percy. He put it very well, that the human association, which in fact produces and distributes the wealth, the association of workmen, managers, technicians, and directors, is an association that's not recognized by law. This is sort of you might think of as the de facto firm, the factual firm. These people who work in the firm, the managers, the workers, directors, and so forth, they're the ones that create this as a community of people that are all actually co-responsible for these results. The law doesn't recognize that. If they commit a crime, then it would recognize that they charge you were involved in that. Instead, what the law recognizes is this other association of shareholders, which are completely absentee in the typical publicly listed company, and are not involved in the actual human association of production at all. So Eustace Percy here is saying this great challenge to our system is to change that recognition by the law. This system, and how you would do it, is essentially to reconstitutionalize corporations, to say that the members of the corporation and the people who work in it is this association of workmen, managers, technicians, and directors, and to reinterpret the shareholders, the absentee shareholders, as essentially loan stock, renter canal, so that the corporation is reconstituted as essentially a democratic community of work, industrial partnership, however you want to put it, and the external involvement of the shareholders is interpreted as a loan. And ironically, of course, that's what it is de facto anyway. I mean, nobody buys shares in a public corporation and thinks it's going to be used for voting. So it's basically an investment anyway. So let's take away the fiction and make that a legal situation where they are simply a variable form of loan capital, like a participating debenture or an income bond where you have a loan capital with some sort of variable return, and then reconstitute the corporation on the basis of the people in the firm being the legal members. So what we talk about now are sort of firm by firm, like in Thomas Russell conversions, but this argument says there is a way in which we can finally, with enough support for these ideas, just reconstitutionalize the corporation itself and have economic democracy. So thank you.
Thank you.